court will note that this is before the court on the defendant's motion to show cause, which was renoticed from last Tuesday, I should say, in this matter. And Ms. McNiff has filed a response. So Ms. Thomas, if you wish to proceed, I don't need you to reiterate your motion. I'm well familiar with that. Maybe respond to Ms. McNiff's answer.
At this point in time, the plaintiff is claiming and alleging that first and foremost that she has followed the letter of the law, which in the letter of the order and the intent of the order, which we believe is absolutely not true. I have a MLS residential active agent detail report for that house, and it indicates the listing date was 1/18/25. So clearly that's when it was listed. It was prior to, after receiving the listing agreement. It definitely said off market when you pull up the house and look at it. It was listed 12 days after the date that it was ordered. Moreover, the house, this court ordered specifically that it was to be sold forthwith, and when counsel requested additional time to even get it listed, the court said no. So I don't know how that could possibly be then interpreted to that it would be okay to list it, not really have it live listing, just have a listing agreement, but it's not live. And also, and then ask for possession 30 days beyond the closing for one thing, which of course we've been accused of being retaliatory at this point. And then also, it was contingent upon the seller finding suitable housing, which was certainly not ordered by this court and does not comply with listed and sold forthwith, which is exactly what the court ordered. We did receive a response from Ms. McNiff yesterday. Again, it's filled with excuses as to why it wasn't timely listed. Irrespective of what a realtor may or may not have suggested, the realtor doesn't trump the court. The court very specifically ordered the house be listed and sold forthwith, and that within 14 days, it was to be listed, and it was not. And the listing agreement was to be given to us within 14 days. We received the agreement, but it wasn't listed, and it wasn't listed until the 18th. Actually,
this is just being redundant now, Ms. Thomas. I'll let Ms. McNiff respond, and then.
Well, you're right. If I can, there's a couple more things that were.
Well, please don't just reiterate everything that's in the pleadings or what you've already said.
Okay. Again, to state that defendant would have claimed that if there wasn't, if she wouldn't have taken all these times, that we would have assumed, and we would undermine it, saying that they were undermining and not trying to get it sold on time, which is speculative at best. But anyway, Mr. Gentry's not receiving proceeds. That's not what this is about. This is just getting the mortgage out of his name. To apply, she's only had 14 days to do it. It's not true. She's had well over 2 years to do it, and it just simply wasn't done. The second paragraph of plaintiff's response is very telling. First, Mr. Gentry and I did discuss the likely price point of, after having looked at the SEV ×2, the taxable value, his knowledge of the home, and after discussing similar homes in the area with a realtor. And again, this court ordered what it ordered, and forthwith meaning immediately, promptly, without delay, done without excuses for delay. And
okay,
that's.
Hold on, Ms. Thomas. That's added nothing to this thing. I'm going to Ms. McNiff at this point. Okay. Go ahead, Ms. McNiff.
Thank you, Your Honor. Your Honor, the order indicates that the listing agreement was to be provided within 14 days. It was provided within 14 days. It does take time to prepare a house for sale. My client wasn't expecting to have to prepare her house for sale. The order doesn't require that the listing go live within 14 days. She went live as soon as she possibly could after making the adjustments that the realtor asked for. It is currently live. As of this morning, there have been 1,786 views on Zillow alone and 195 saves. So this idea that she has it listed too high, again, Ms. Thomas is not a realtor. Her client is not a realtor. Without some sort of expert testimony, I don't think the court can determine whether or not the price range is too high for this particular house. There certainly is interest in it. There have been showings of it. My client is doing everything she can to get this house sold. However, it's reasonable for her to ask for to maintain possession 30 days after closing. In the event that she doesn't have a place to live, she will need at least 30 days to find a place to live. Hopefully she can find a place to live prior to that. But if she gets an offer tomorrow, she's going to need a little bit of time. We're in compliance, Your Honor. This is simply a harassing tactic on the part of Mr. Gentry.
Okay. Well, if she gets an offer tomorrow, she's not going to close tomorrow. There's going to be obviously sufficient time for her to make arrangements. The court did not put any conditions on the listing or sale back when the court ordered it back on January 3rd of 2025. So the court isn't going to allow parties to come in and unilaterally put conditions. So the court is going to order that the property would be sold without conditions. So her condition about finding suitable housing or staying after closing have to be removed in this manner. She'll have to get out of the house at the date of closing like everybody else does when they sell a house. The court will leave the price at the current amount because it does appear that there's been interest in that, and we'll see if there's some offers. If we have to adjust the sale price, then you can bring it back in at that point, and we can adjust it if the parties are not willing to agree. So Ms. Thomas, you can prepare that order reflecting that, and we'll hopefully move along and get the matter sold as quickly as possible.
Your Honor, as long as the plaintiff did not do it pursuant to the order and added conditions that weren't approved by the court, Mr. Gentry had to bring it back. Is there any way he can get attorney fees? This is, it wasn't done the way it was.
I'm going to reserve that at this point.
Okay. Okay, thank
There you
you.
go. Have a good day.
Thank you.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion to require plaintiff to comply with the judgment of divorce. Obviously, I've read the pleadings in this matter, Ms. Thomas. You don't have to reiterate those. Do you have anything in response to Ms. McNiff's answer?
Well, there's a lot of things to respond to because there was a lot of inaccuracies in there.
Well, let's respond to the salient points. There was a lot of ancillary and I believe superfluous stuff included, and I don't need you to respond to that.
Okay. All right. So the issue is, of course, whether or not and when Ms. Gentry, Ms. Tinsman has to respond or has to remove his name from the obligation. The concern is that now we've learned that her intent is to not do so for another 18 months. The problem, or to even list the house for sale for another 18 months, which would even be beyond that. But the problem of it is that it's affecting Mr. Gentry's credit. It's affecting his ability to do other things at his house and ownership of his house. And so it was supposed to be to hold him harmless. And in the response, there's several things that aren't true, including, you know, who had the affair. I mean, there's all kinds of things. But again, as you indicated, they're ancillary things. The bottom line of it is this case was one where Ms. Tinsman's attorney drew up the document. Mr. Gentry was not represented. It was after he had met with both of the parties, and they both were of the understanding at that point that she was going to refinance and get this taken care of right away. It's now more than 2 years later, and nothing's been done. And it seems that Ms. Tinsman is of the belief that she can do this if and when she wants to, and it is affecting his credit. It is affecting, there's all kinds of excuses, but every excuse is one that frankly is under Ms. Tinsman's control. We just are asking for a date by when it needs to be done, because one wasn't put in the initial judgment of divorce that was prepared by Ms. Tinsman's attorney. And then again, the amount of things in the response were a little flabbergasting for us, quite frankly, but there are 5 missed payments according to the document from the credit union. And so we're just simply asking that there be a timeline put on this matter.
Okay, thank you. Ms. McNiff, you talk about all sorts of things in the response. What's the date that she'll have this refinanced by?
Your Honor, as we responded in detail. The problem she's going to have is that the financing companies want her to have 2 years of either W-2 or 1099 wages. And she simply doesn't have that. And so she won't be able to refinance until then. She certainly wants to sell the house sooner than 18 months. But we need a resolution of the parenting time issue. I'm going to have to file a motion, I think, to resolve that and to get that to a hearing.
Okay,
But
that's not before me today.
no, I'm just, and I understand that. She has an
Give
intent
me
to
a date.
sell.
Give me a date.
I don't have a date, Your Honor. I don't. But the big thing here, Judge, is a judgment of divorce for the property provisions is really a contract. And it's not for the court to reform the party's contract. It should have been on Mr. Gentry to ask for a date when he wanted his name off of that property. And without that being in the judgment, there is no date. I think that
Okay, that's fine.
Mrs. Tinsman will do it, but the judgment speaks for itself.
Okay, well, in this matter, it's been approximately, the judgment was back in on February 13th, 2023. So we're going on close to a year. Obviously, that's sufficient time to get the matter resolved, and the court's not going to wait indefinitely for the plaintiff to qualify or whatever. And because we can't be given a date, the court is going to order that the house be sold, listed for sale forthwith, and be sold. If something happens in the meantime, she's able to refinance, the court would consider that. But at this point, if there's no date, that she's going to have to list it for sale and have it sold forthwith, and provide Ms. Thomas with the listing agreement. I will require that be done within 14 days of today's date.
Judge, could she have a little bit more time just
Nope.
due to the holidays? It's going to be
She's had
difficult.
sufficient time. She can do it within 14 days. Thank you.
Okay. Thank you, Judge.
Thank
got it.
you.
You can submit that, Ms. Thomas, under a 7-day.
Will do. Thank you.
Thank you. Have a good day and a good holiday.
Thank you.
Thanks, you too.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Thomas on behalf of defendant. Matter is before the court on the plaintiff's motion to modify parenting time, as she says, due to the intent of the plaintiff to move to Virginia. Go ahead, Ms. McNiff.
Thank you, Your Honor. I know the court is familiar with this case and has read the pleading, so I'd like to just respond to the answer if that's acceptable to the court.
That's fine. I don't need a reiteration of everything in the pleadings.
Thank you, Your Honor. First of all, we're offended by the fact that in the answer, they indicate that my client became pregnant with her boyfriend. In fact, my client was engaged to her now husband when they had an unplanned pregnancy. We feel like that's simply a dig that was unnecessary in the answer. But the big issue here is that Attorney Thomas indicates in her answer that the referee could have set up a parenting time plan after the change of domicile hearing, but didn't based on the children's best interest. The fact is that the time of the hearing, there was no request by either party to have a change in parenting time if there was no change in domicile. The request was to change the domicile and change the parenting time in conjunction with that change of domicile. The court denied the change of domicile and simply did not have a change of parenting time because that request wasn't on the table. Mrs. Tinsman has now made the decision to accept that finding and intends to move to be with her husband and their infant child in Virginia at the time that the Battle Creek house sells. While the court certainly has the authority to prevent the children from moving to Virginia or changing their schools, Mrs. Tinsman is free to move to be with her husband as she sees fit. Mrs. Thomas believes that the parties can continue with the current week on, week off parenting time schedule even after my client moves to Virginia, but that's simply untenable. It's ludicrous to think that anybody could do that. Mrs. Tinsman has a 7-month-old child who will eventually attend school. The party's youngest child is 6. To think that Mrs. Tinsman can travel every other week from Virginia to Michigan for the next 12 years is absolute insanity. She can't afford to buy a residence in Michigan now that her house has been ordered to be sold, and she can't afford the high cost of rentals on a bi-weekly basis. there needs to be an alternative parenting time plan put into place that accounts for this move. This is going to be a big issue when this house sells. Ms. Thomas argues that the house selling and Mrs. Tinsman moving is not an ordinary life change, but she's simply wrong, and it's absurd it's an absurd argument that this court should absolutely not entertain. Selling the family home and moving out of state is absolutely an ordinary life change as contemplated in Shade v. Wright. We could wait until the house sells and then renew our motion, but we think that it makes sense to prepare for this eventuality in the event that the house sells very quickly. The court ordered that the house sold. There is a listing agreement. The listing for the house is going to go live this coming weekend with photographs, and we would anticipate that it will sell fairly quickly. Ms. Thomas also indicates that we're asking for a 50-50 parenting time split, which she knows is absolutely untrue because she sent us a proposed parenting time plan and we sent a counteroffer, and neither contemplated a 50-50 split. It's simply ridiculous to think that the parties could live in Virginia and Michigan and have a 50-50 parenting time split. We know that can't happen. She further argues against herself, saying on the one hand that an equal time division isn't necessary for joint physical custody, and on the other hand insisting that Mrs. Tinsman maintain the equal division of parenting time by commuting. We understand that there can't be a 50-50 split. We've never been proposing that, even when we were asking for a change in domicile. I'm frankly incredulous that Ms. Thomas alleges that Mrs. Tinsman wants to take away all of the school holidays from Mr. Gentry when she knows that that is absolutely false. Mr. Gentry's offer was in accord with our counteroffer, and the parties were in agreement on all of the major school holidays, including Memorial Day, Labor Day, Martin Luther King Day weekend, the midwinter break, the spring vacation, the Christmas vacation, and the Thanksgiving vacation. Where they got hung up on was how much time each of them would have during the summer vacation, the Independence Day holiday, and who would pay for transportation. Those were the big hangups. So to say that we're asking for all of the school holidays and making that seem like my client is being selfish is absolutely fallacious, when that was part of a proposal that they sent to us. The big issue here, Your Honor, really is who's going to pay for or provide the transportation for the parenting time when my client moves to Virginia. This court's policy in the past to not necessarily make that an equal division. The moving party should bear perhaps more of it, but it's also never been this court's policy that one party has to bear the entire burden of transporting the kids for parenting time. We're not asking that there be even a 50-50 split of the transportation burden, but we are asking that Mr. Gentry be required to do some of the transportation, perhaps for the big holidays like Christmas and summer and spring break, Thanksgiving, things like that. Further, Ms. Thomas complains that we haven't complied with the order regarding the sale of the house, which is again absolutely false. The order that Ms. Thomas drafted specifically provides that we were to provide a listing agreement 14 days from December 23rd of last year. We provided the listing agreement to her on January 6th of this year, which was within 14 days, in spite of the Christmas holiday and in spite of the New Year holiday. Mrs. Tinsman was scheduled to meet with a realtor prior to January 4th, but the realtor contracted pneumonia and had to move the meeting to January 4th. The realtor then asked Mrs. Tinsman to ready the house for photographs. There's 4 small children living in this house, and my client had to declutter, clean, make repairs, wash crayon marks off walls, and do things like that in order to get this house ready for sale. She's been diligently working on all of those tasks since her meeting with the realtor on January 4th. And the house is now ready for professional photographs, which will occur on January 16th this week. And the listing will go live this weekend. The realtor felt that it's better to go live on a weekend in order to generate more interest, and also to have the house decluttered, looking good for the photographs so that people will have more interest in the house. Your Honor, this shouldn't be a difficult case. These cases come up all of the time. People are able to work through them. However, these parties can't, and we need the assistance of the court to try to figure out a proper parenting time schedule that will maintain joint physical custody, although we're not asking for 50-50 time, and accommodate the fact that my client wants to move to Virginia to be with her husband and their small child. The way we see it, the big differences are the summer vacation and how many weeks each party will get during the summer vacation, the 4th of July holiday. My client is looking for 1 weekend per month during the school year to be exercised in Michigan. And she would do all the transportation for that. And we're looking for some kind of division of the transportation.
Okay, thank you. Ms. Thomas?
Your Honor, a couple of things. First of all, that was not, I mean, the specificities of the parenting time was certainly not before the court, but the bottom line of it is, though, that in fact, the motion that Ms. Gentry-Tinsman filed with the court initially was a change of domicile and a change of parenting time. Clearly, that motion seems to have reported that if in fact there was a move, parenting time would have to change. And that's fine, but throughout the course of that particular hearing, and which was like 13 months, Mr. Snyder considered a variety of things, and specifically, he noted in his finding that Ms. Gentry was going to have to make some specific decisions about, did she choose to live with her children in Michigan or be in Michigan with her children, or did she choose to be with her husband and a new child, and that decision would be very, very difficult for her, and it's in the finding. So clearly, the court heard very significantly, in fact, about the new child, and again, there was no intent about boyfriend, fiance, not husband at any rate. Her husband, her child, the fact that she intended to move. So the court knew all of those things, and still, even though parenting time was before the court, did not fashion any kind of order that if in fact, and after specifically stating that she would have to make these difficult decisions, did not in any way indicate, well, if she chooses to move, then it would be this parenting time. And the court had authority to do that and could have done that, but the court didn't do it. And we find it, I find it very interesting this morning that specifics of what the specific issues are between the parties was brought to light when Ms. McNiff last week was upset because I said anything that there was a motion or a offer at all. The bottom line of it is that for the last year and a half, Ms. Tinsman has gone back and forth. If she chooses to, I mean, yes, the court ordered the house to be sold. It is not listed at this point in time. Irrespective of what Ms. McNiff has said, at this moment, it's not listed. And it doesn't even have to be sold. This court specifically gave the option that if in fact she got it out of Mr. Gentry's name, that it didn't have to be sold. So that is another option. She's been doing it for a year and a half. I understand that that's a lot, but I also believe that Ms. McNiff was not quite 100% honest, and not that she's being dishonest, but she left out a few things. Number one, that the initial offer was the same as what they had put in their motion for change of domicile reversed. In other words, she was willing to go the extra mile to have Mr. Gentry agree that in fact her motion would be accepted, and ultimately expected us to do the same thing. Well, he didn't want the children to necessarily move. He doesn't necessarily want the children's mother to live that far away from them. Bottom line of it is there was an offer, we countered. Our counter offer from that, they asked for more time than they asked for in the very beginning. So that, to us, that wasn't even a realistic negotiation. At this point, the court has looked at the facts of the case, knowing that there's a new husband, knowing that there's a new child, knowing that the defendant intended to move. There's no change in those circumstances. She intended it before, she intends it now. And so I don't believe there is a change. Again, selling the marital home does not mean that she necessarily has to move. The house is in her husband's name as well. They can either pay it off or refinance or somehow get Mr. Gentry's name off the mortgage. That would comply with the court's order. And again, the status quo for the last year and a half has been going back and forth. Although Ms. McNiff has indicated that that they're not asking for 50-50, Ms. Tinsman continues to refer to a plan wherein she could move and maintain joint physical custody of the parties' children. And as Ms. McNiff indicated this morning, it is unrealistic to assume, because plaintiff's unilateral choices that and her wants and desires, that she would solely determine the children's time with their dad either. As pointed out in our answer, again, it doesn't have to mean 50-50. And depending upon her choices, she can continue with equal parenting time if she wants to, if she chooses to stay in Michigan. But she wants to move and she wants to take the kids away from their dad and their friends and it's not, when we're talking about school holidays, we're not talking about it. The intent was not to talk about holidays as in Memorial Day, but holidays as in the non-school time. Clearly, it would not be equitable or in the children's best interest to never be able to have vacation time with their dad, because their entire summer would be with their mom. And that's a big part of what Ms. McNiff did leave out in what she indicated to the court this morning. The court has already said and ruled when Ms. Tinsman asked last summer to take summer parenting time in 2-week increments, that no, it's not in the kid's best interest. And so even though it would have been more convenient for her. So bottom line of it is, Mr. Gentry wants the kids to have a meaningful relationship with their mom, and he's willing to work with her. He offered a parenting plan, which quite frankly was a little more generous than what I thought that he would offer, or that I thought, quite frankly. But it would allow regular continued parenting time with the children if mom chooses to move. That was declined, and more parenting time than what had initially been asked for was asked for. The plaintiff suggested resolution wherein the kids would no longer enjoy extended summertime with their dad, where plaintiff's parenting time would not be supportive of the kids' events and activities. That's not focusing on the kids, or it's not putting their best interests first, and therefore it's not acceptable to Mr. Gentry. And quite frankly, it's also not in compliance with Michigan court case law. Your Honor, the court has heard about plaintiff's new husband, the new child, her desire to move, her intent to move. She's brought up nothing in this particular motion that's not already been before the court, and frankly, to ad nauseum. And frankly, she's not met her burden of proof for a change of parenting time. Frankly, Mr. Gentry can't continue to pay for ongoing attorney fees merely because the plaintiff doesn't like the prior orders of this court. He's praying his request for attorney fees will be granted so that the ongoing motions will stop. Again, whether this court orders an evidentiary hearing or not, Mr. Gentry is willing to work with Ms. Gentry with regard to, or Ms. Tinsman with regard to the parenting time, but to have this ongoing, constantly, forever in front of the court and expense, he can't afford to continue doing it when it's every time it's been because Ms. Tinsman doesn't like the last order of the court. So we're asking that the motion be denied, and that first of all, it may not be right because she's not moving right now, but again, there's options. It's not, the only option is not that she would live there and the kids would live here and she couldn't have alternate week parenting time. She can if she wants to. The house doesn't have to be sold. The court didn't order that. The court said if she wanted to, that the court would consider refinance or paying it off or whatever it would have to be. I don't believe that this is a motion that is well advised. I believe this court has already heard this, and Mr. Snyder, it took him a long time to do his finding. And I know that both Ms. McNiff's office and my office are both saying, when are we going to get the results? Because it did take him a long time, because it put a lot of careful consideration into this. And to now go back and do a redo doesn't seem necessary. First of all, I don't believe it's properly before the court showing a change in circumstances, but it also is very expensive. And Mr. Gentry can't just keep shelling out money because that the order of the court isn't the one that Ms. Gentry or Ms. Tinsman would like. So we're asking that the motion be denied in its entirety.
Okay, thank you. Well, in this case, I do note that Ms. Thomas had stated that at the hearing that the referee had stated and in fact had not fashioned any change in parenting time. And as she stated, apparently the referee had also queried again if the plaintiff was going to move. So there was apparently some uncertainty in that. It does sound now that she's moving, and obviously moving that amount of distance is a change pursuant to Shade v. Wright. And what the court does note is that the referee has the experience with this case, having gone through that. So the court is going to refer the issue of parenting time back to the referee for a hearing in which he can fashion a parenting time schedule, considering that the plaintiff is in fact moving to Virginia. So that will be the order, and court will do a referral order. Ms. McNiff, you don't have to do that. That will be the order of the court, and just to wait, you'll get a hearing notice from the referee. Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Thomas on behalf of defendant. This matter is before the court on the plaintiff's motion to modify support with regard to child care expense. Ms. McNiff.
Your Honor, I would just note for the record that my client is recently remarried and her new last name is Tinsman. This is really a pretty simple motion. Right now, the parties are required to each pay 50% of any child care expenses. That was an agreement that they reached in their original judgment of divorce. Since that agreement was reached, my client is on has a different job. She's remarried. She has a baby. She had to leave her previous job, which still had her making significantly less money than Mr. Gentry, as a result of there not being sufficient PTO to get sufficient sick time. She at one point was taking care of the children when they had COVID during Mr. Gentry's parenting time. The kids have had some significant medical issues, some like tube surgery, things like that, that she's had to take time off for, and she simply couldn't do it with the previous job. So she took a remote job so that she could meet those obligations. We've also been in court a lot, which was a difficulty for her and with her previous job. So we're simply asking that the child support provision not be 50-50, that it be pursuant to the appropriate Michigan child care formulation that would assign the parties. We do have this matter currently in front of referee Snyder on a change of domicile request, change of custody, change of parenting time. However, this particular part of the child support formula was not an issue. And I think in order to get it there, the court needs to rule on it or send it to referee Snyder.
Okay, thank you. Ms. Thomas, any response?
I do, Your Honor. I don't think it's as simple as what Ms. McNiff purports it to be. Our answer to the plaintiff's motion certainly sets forth the defendant's position regarding the 50-50 child care. However, I would add that to clarify, I just want to clarify a couple of things. First, at the time of filing our answer, this motion hearing was scheduled for last week. So we had said there was 9 days before we'd be in front of court again. We're actually in front of Mr. Snyder again on Wednesday of this week. And so there's no reason that this motion couldn't have been brought at that hearing. This is just an extra motion for no particularly good reason other than it cost Mr. Gentry a lot of money. But more to the point, the parties negotiated. And they reached, it was by the judgment of divorce was entered by consent. And part of their negotiation was that because Mr. Gentry for a while was working at home, because that was part of what his job was doing, that's not the case anymore. And there was some variables, but the parties agreed that it should be 50-50. And that's what they agreed to that. And that's part of the other issues in the case settled because of that. So therefore, that was a negotiated agreement and it wasn't part of it. And if you look at the uniform child support order, So it's purported that it's in there. It's not in there. And if you look at the formula that's attached, the calculations attached, it's not on there. It does not say that at all, because the parties had agreed that it was going to be 50-50. If it was summer, if it was before and after school, whatever it was going to be, it was going to be 50-50, because that was part of the settlement that they reached based upon all the totality of the circumstances of their particular case. For clarification, in plaintiff's motion regarding change of domicile, she specifically requested relief as it relates to childcare in this matter. And Mr. Snyder has in fact heard testimony as it relates to the issue of childcare. In plaintiff's motion regarding change of domicile legal residence, although she indicates that she's also asked for custody and parenting time, in her motion, that's not true. In her motion, she acknowledged childcare expenses for the children under the age of 12 are to be paid 50-50, and specifically requested reimbursement regarding questionable childcare expenses. So this issue of childcare between these parties is already in front of Mr. Snyder, and he's already heard testimony. So to have yet another motion that we can again prepare for yet another motion, another thing, is ridiculous. And also, frankly, one of the many reasons that Ms. Gentry used to persuade this court that she should be allowed to take the kids with her to her new boyfriend, now husband's home in West Virginia, was that she was offered a job less than 5 minutes away from her then boyfriend's home. And it was at a State Farm agency, and it was contingent upon her being able to move there. And then she quit her job at State Farm here. And that was all as a furtherance of her career. That was one of the big things, that reason that she, was going to do this. And now she quit her job. She worked at another job. She worked full time. She said she was going to only work part time. There's been like, it was this and it's like, and the testimony and the actions don't match. And she was going to have, and specifically, I believe that she said that plaintiff alleged in her motion that her fiance is, quote, supportive of a part-time work arrangement for her. His career is stable and he is well compensated, which will enable a more relaxed professional schedule for me. Yet she quit her regular job. She took a full-time independent contractor job, if you will, with no benefits. And then now and because of this the financial affordability, because of her fiance's and now husband's income. And now here we are. We already agreed on this. This is something that they negotiated before Lisa was involved, before Ms. McNiff was involved, before I was involved. And now here we are saying, oh, well, wait a minute, that's not affordable now. I mean, I think she used to use her new financial windfall, and she needs to suck it up. That was their agreement. This is, again, 1/2 share of childcare expenses is what they agreed to. And it's not included in the uniform child support order. This issue with regard to who's going to pay what for last summer is before referee Snyder. So this issue was already in front of him. And this, again, another motion that the plaintiff has brought that we have to prepare for, get ready for. And we're just asking that the court uphold the current order of the court, the judgment of divorce, which is the court order by consent of the parties. Although Ms. Gentry indicated that she has paid her 50% of childcare. She has not. She's not paid anything this summer at all. And now we have attorney fees in addition. And it's the same subject matter that's already before Mr. Snyder, that he's already taken testimony as to these issues, in fact.
Yeah, I don't have to have that read. I've heard that probably 3 times already, Ms. Thomas. What I'm going to do in this matter is, obviously, the judgment of divorce provides for 50-50 in childcare costs. It was by the consent of the parties. The court has not heard any reason why the court should invade and modify a judgment that was entered into by agreement of the parties, consideration of all the issues. The court is going to deny the motion. Ms. Thomas, you can prepare that order and submit under 7 days.
Your Honor, will the court consider our request for attorney fees?
I'm not going to at this time.
Okay, thank you.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion to require plaintiff to comply with the judgment of divorce. Obviously, I've read the pleadings in this matter, Ms. Thomas. You don't have to reiterate those. Do you have anything in response to Ms. McNiff's answer?
Well, there's a lot of things to respond to because there was a lot of inaccuracies in there.
Well, let's
The
respond to the salient points. There was a lot of ancillary and I believe
Right.
superfluous stuff included, and I don't need you to respond to that.
Okay, all right, so the issue is, of course, whether or not and when Ms. Gentry, Ms. Tinsman has to respond or has to remove his name from the obligation. The concern is that now we've learned that her intent is to not do so for another 18 months. The problem, or to even list the house for sale for another 18 months, which would even be beyond that. But the problem of it is that it's affecting Mr. Gentry's credit. It's affecting his ability to do other things at his house and ownership of his house. And so it was supposed to be to hold him harmless. And in the response, there's several things that aren't true, including, who had the affair. I mean, there's all kinds of things. But again, as you indicated, they're ancillary things. The bottom line of it is this case was one where Ms. Tinsman's attorney drew up the document. Mr. Gentry was not represented. It was after he had met with both of the parties, and they both were of the understanding at that point that she was going to refinance and get this taken care of right away. It's now more than 2 years later, and nothing's been done. And it seems that Ms. Tinsman is of the belief that she can do this if and when she wants to. And it is affecting his credit. It is affecting, there's all kinds of excuses, but every excuse is one that frankly is under Ms. Tinsman's control. We just are asking for a date by when it needs to be done, because one wasn't put in the initial judgment of divorce that was prepared by Ms. Tinsman's attorney. And then again, the amount of things in the response were a little flabbergasting for us, quite frankly, but there are 5 missed payments according to the document from the credit union. And so we're just simply asking that there be a timeline put on this matter.
Okay, thank you. Ms. McNiff, you talk about all sorts of things in the response. What's the date that she'll have this refinanced by?
Your Honor, as we responded in detail, the problem she's going to have is that the financing companies want her to have 2 years of either W-2 or 1099 wages. And she simply doesn't have that. And so she won't be able to refinance until then. She certainly wants to sell the house sooner than 18 months. But we need a resolution of the parenting time issue. I have to file a motion, I think, to resolve that and to get that to a hearing.
Okay,
But
that's not before me today.
No, I'm just, and I understand that. She has an intent to sell.
Give me a date.
I don't have a date, Your Honor. I don't. But the big thing here, Judge, is a judgment of divorce for the property provisions is really a contract. And it's not for the court to reform the party's contract. It should have been on Mr. Gentry to ask for a date when he wanted his name off of that property. And without that being in the judgment, there is no date. I think that
Okay, that's fine.
Mrs. Tinsman will do it, but the judgment speaks for itself.
Okay, well, in this matter, it's been approximately, the judgment was back in on February 13th, 2023. So we're going on close to a year. Obviously, that's sufficient time to get the matter resolved, and the court's not going to wait indefinitely for the plaintiff to qualify or whatever. And because we can't be given a date, the court is going to order that the house be sold, listed for sale forthwith, and be sold. If something happens in the meantime, she's able to refinance, the court would consider that. But at this point, if there's no date, that she's going to have to list it for sale and have it sold forthwith, and provide Ms. Thomas with the listing agreement. I will require that be done within 14 days of today's date.
Judge, could she have a little bit more time just
Nope.
due to the holidays? It's going to be
She's
difficult.
had sufficient time. She can do it within 14 days. Thank you.
Okay. Thank you, Judge.
Thank you.
You can submit that, Ms. Thomas, under a 7-day.
Will do. Thank you.